We're talking about the patent case between Gillette and Energizer Holdings that the Federal Circuit addressed in 2005. Before we talk about the case itself, let's talk about the patent that was at issue in that case and the parts of an actual patent document. As you can see here, the patent that was at issue in the case between Gillette and Energizer Holdings was United States Patent 6,212,777. Patents are numbered in order, from the first patent granted in the United States up to the patents in the 8 millions that are being granted in the year 2013. On the face of the patent, you can see general summary information, including the named inventors on the patent. Here there are two. The assignee of the patent, the Gillette Company, the date the patent issued, April 10th, 2001, and the dates where various parts of this application were filed. This patent was originally filed in Great Britain on September 29th, 1993. Within a year thereafter, they filed what's called a PCT application, which is an international application that we'll talk about later in this video series. After filing that PCT application, they elected to pursue a United States patent, which we're looking at now, which eventually issued in 2001. On the face of the patent, you also see the prior art. These are the publicly available documents that the examiner looked at to determine whether the invention that Gillette was seeking to patent indeed was new and non-obvious and deserving of a United States patent. On this first page, we also see the name of the examiner, one of the 7,700 examiners that work at the Patent and Trademark Office that looked at this application, the law firm that represented Gillette in seeking this patent, an abstract and a represented drawing that generally describe this technology and allow people to understand the general nature of this patent. After the first page, you'll see what most patents have, which is a series of drawings. These drawings give people an idea of various examples of the patented technology. But as we'll discuss in a second, these drawings do not define the scope of the patent rights. This is a relatively short patent compared to most. It has figure 1, figure 2, and that's all. Probably most patents will have many other figures than this. After the drawings comes a general description of those drawings and the nature of the technology disclosed in the patent. The most important part of the patent comes on page 4 of this patent. That is the claims. The claims are what define the scope of Gillette's patent rights. If you think of patent rights as property rights, you can think of the claims as establishing where the fence is around one's yard. In this patent, there's claims 1 through 11. Each claim represents a unique set of rights held by Gillette. Typically, the first claim is the broadest and the one that most people would start looking at. A claim is made up of a single sentence where the patentee tries to define the scope of their patent using words. Now understand that one would look at a patent for a couple different reasons. If you're looking at a patent to determine what technology it covers, what's covered by its claims, then you need to look at the claims of the patent first. Now, in order to understand what these actual words mean, you'll probably also look back at the specification, including the drawings, to understand how the patentee is using these words to define the scope of their rights. If you're trying to determine whether a patent actually covers new and non-obvious technology, you also look at the claims. Again, it's the claims that define the scope of your invention. In order for an invention to be patentable, that claim needs to be new and non-obvious, and we'll talk about those concepts later in this series. A patent, though, also makes up prior art that a subsequent patentee would look at in trying to determine whether their invention is new and non-obvious. So, for example, this Gillette patent issued in 2001. If someone was seeking to patent certain aspects of razor geometry after 2001, an examiner may look at the teachings of this Gillette patent to determine whether the subsequent patentee is actually seeking to patent an invention that's new and non-obvious. For this purpose, you'd look at the Gillette patent in its entirety, all of its teachings, including its claims, its drawings, and its specification. The entire teaching of the patent is relevant in determining what information is part of the public domain and can't be patented later on. So now we've looked through the parts of a typical United States patent. Next, we'll talk about how we figure out the scope of one's patent rights and how they're used in protecting one's marketplace.